Hello and welcome to LiveLaw Daily, your quick and no-noise breakdown of the most important legal developments from courts across the country. I'm Debojit Das, and here are the top stories from today. So for our first story is an order from the Patna High Court today, one that puts the rights of farmers at the center, invoking Articles 14 and 21 of the Constitution. A division bench of Chief Justice Sangam Kumar Sahu and Justice Harish Kumar was hearing Sanjay Kumar and others versus State of Bihar and others, a case concerning farmers in Muzaffarpur who suffered crop losses due to national disaster but were left out of compensation. The Agriculture Department's position had been that the Rabi season had already commenced, making disbursement under the scheme no longer possible. The court was told that while 1,11,861 farmers had already received compensation totaling over Rs 33 crores through the DBT portal, which closed on December 2nd, 2025, that's a number of genuine claimants had been left out. The bench was clear here as procedural barriers cannot be used to deny compensation to farmers whose crop loss had already been assessed and documented. A 3-member committee has now been constituted by the Agriculture Department to conduct field verification in the affected panchayats, identify leftover claims, and submit a consolidated report within 15 days. Authorities have also been directed to run proper awareness campaigns so that remaining affected farmers can appear before the committee. The court's message here invoked the right to livelihood. The farmer who feeds the entire nation cannot be left to fend for himself when natural disaster strikes. From farmers' rights, we now move to a matter before the Calcutta High Court that could have significant implications ahead of Eid ul-Azha celebrations in West Bengal. With Eid being celebrated around 27th May and 28th of this week, a legal battle over West Bengal's cattle slaughter restrictions reached a flashpoint at the Calcutta High Court today, and the division bench of Chief Justice Sojoy Paul and Justice Partha Sarthi Sen heard the final round of arguments. So some backdrop first. The West Bengal government issued a notification under the West Bengal Animal Slaughter Control Act of 1950, which requires a fit certificate before bulls, bullocks, cows, calves, or even buffaloes can be slaughtered. Under the notification, only animals above 14 years of age or those permanently disabled due to injury or disease would qualify. The petition challenging this was moved by TMC MLA Akhruzaman, with TMC Member of Parliament Mahua Moitra also appearing during the hearing. Senior advocate Shadan Farasat, appearing for Moitra, made a pointed argument here. As he said, the practice of Qurbani on Bakri Eid requires a healthy animal, not an old or mutilated one. The very animals the state says are eligible are precisely the ones Islamic tradition says cannot be used for sacrifice. Farasat also stressed that the West Bengal law itself carries an exemption clause for religious purposes, and if that exemption cannot apply in a situation like this, it serves no purpose at all. On the other side, the Additional Solicitor General told the court that the animal sacrifice on Bakri Eid is an optional religious practice and therefore not protected under Article 21 of the Constitution. The court has reserved its order, and with Eid ul-Azha just days away, the ruling is being awaited by many. And moving on to our third story. From constitutional questions around religious practices, we now move to a major development in the Delhi riots' larger conspiracy case today. The Delhi High Court has granted bail to Salim Malik, one of the accused in the case. A division bench of Justice Pratibha M. Singh and Justice Madhu Jain passed the order today after hearing Malik's counsel and Delhi Police's prosecutor. Malik had been fighting for bail since at least January 29th, when the trial court denied it. The High Court had issued notice on his appeal back in February. He is among a large group of accused, including Umar Khalid, Tahir Hussain, Devangana Kalita, and Natasha Narwal, among others, who face charges under the UAPA and the IPC for allegedly formulating what the prosecution calls the larger conspiracy behind the communal riots of February 2020. A detailed order is still awaited at the time of recording. Meanwhile, the Patna High Court also dealt with an important service law dispute concerning recovery from a retired university employee. Here's a case from the Patna High Court that will resonate with anyone who has spent a career in government service and built their retirement plans around a settled pay scale. Pitambar Jha joined RN College as a typist cum assistant back in 1968. Over the decades, he became a permanent university employee of Ellen Mithila University after the college was taken over by the state, and was eventually promoted as head clerk of accounts with effect from January 1st, 2006. That was too on the recommendation of the university's own select committee. His pay was fixed by the university's statutory pay fixation committee in a higher pay band, and he retired on June 30th, 2010 with his retiral dues calculated accordingly. Then 12 years after his retirement, the state's pay verification cell issued a fresh certificate slashing his pay scale significantly. No notice and no hearing. Justice Ritesh Kumar of the Patna High Court found this unsustainable on two grounds. First, the pay verification cell has no jurisdiction over pay fixation of university employees where a statutory pay fixation committee exists. Second was the settled law, including the Supreme Court's ruling in State of Punjab versus Rafiq Masih and Thomas Daniel versus State of Kerala, which bars recovery from retired employees in these circumstances. The pay verification certificate was quashed, and the 22 lakh rupees, if already deducted, is to be refunded within 3 months. From service law, we now turn to a politically charged hearing before the Delhi High Court involving BJP MP Raghav Chadha. BJP Member of Parliament Raghav Chadha's plea before the Delhi High Court today asked the court to take down content that he says portrays him as someone who sold himself for money. As you already must have figured it out by now, that's a reference to his shift from AAP to BJP. He also sought a John Doe order against unknown entities to stop anyone from using his photos or personal traits without consent. Justice Subramaniam Prasad was not particularly receptive. Right at the outset, the court told his counsel, senior advocate Rajiv Nair, that on the face of it, there was no personality right involved here, and that the posts looked like criticism of his political decision, not a violation of any protected right. When Nair pushed back, arguing that the narrative of Raghav Chadha as someone who switched parties for money couldn't be passed off as criticism, the court here pointed out that there's a difference between commercializing personality rights, which courts have protected in cases involving Shashi Tharoor and Pawan Kalyan, and criticizing a politician for a political decision he made. The latter, the court said, is a matter of debate at best. The court has reserved its order on interim relief and said it may appoint an amicus to assist. And from political speech and personality rights, we move to Tamil Nadu, where the Madras High Court is now examining allegations of electoral corruption during the recent assembly elections. Tamil Nadu Chief Minister Joseph Vijay is barely weeks into office, and the legal challenges are already stacking up. The latest comes from the Madras High Court, which has issued notice on a public interest litigation filed by advocate L. Vasuki, alleging corrupt practices during the 2026 Tamil Nadu assembly elections. And the allegations don't spare anyone. They cover all three major parties, TVK, DMK and AIADMK. One allegation in particular stands out, and it's aimed directly at Chief Minister Vijay. As TVK's president, Vijay is alleged to have called upon children during the election campaign to emotionally pressurize or influence their parents into voting for TVK. The petitioner argues this squarely amounts to undue influence under Section 123 of the Representation of People's Act. The PIL also points to widespread cash for votes and electoral bribery across multiple constituencies, with the Election Commission, according to the petitioner, sitting on its hands despite complaints that were widely in circulation. The bench of Justice G.R. Swaminathan and Justice V. Lakshmi Narayan has identified a genuine legal question sitting at the core of this case. Election petitions under the Representation of People's Act are typically filed against individual candidates, but can an entire political party be declared disqualified under Section 100, which lays out the grounds for voiding an election? The court said that needs proper examination and has issued notice to the Election Commission and all the three parties. The petitioner is seeking a time-bound independent inquiry into the conduct of all three parties during the election. What do you make of these allegations? Comment down below and we would love to hear your thoughts. Now to a crucial Supreme Court ruling interpreting the safeguards introduced under the Bharatiya Nagarik Suraksha Sanhita or BNSS. Here's a Supreme Court ruling that matters a great deal for anyone facing prosecution by the Enforcement Directorate, and more broadly for how the new safeguards for BNSS interact with PMLA cases. The case is Parvinder Singh versus Directorate of Enforcement, decided by a bench of Justices M.M. Sundaresh and N. Koteshwar Singh. The facts are straightforward. An Enforcement Directorate prosecution complaint was filed against Parvinder Singh under PMLA on June 24, 2024. That was 1 week before the BNSS came into force on July 1st. The special court took cognizance on July 2nd, 1 day after the BNSS kicked in, but without hearing the accused first. And that's the problem here. The BNSS introduced something the old CRPC did not have: a first proviso to Section 223 subsection 1, which mandates that in complaint cases, the BNSS introduced something the old CRPC did not have: a first proviso to Section 223 subsection 1, which mandates that in complaint cases, the accused must be given an opportunity to be heard before a court takes cognizance. The ED's position was threefold. 1. The PMLA is a standalone statute. 2. The old CRPC governs because the complaint predates the BNSS. And 3. In any case, the accused suffered no prejudice. The Supreme Court rejected all three. The court held that Section 223 subsection 1's proviso is not a procedural nicety. It is a substantive right flowing from Article 21's guarantee of a fair trial. The word shall makes it mandatory, and crucially, the accused does not need to prove prejudice. Skipping the hearing is an illegality that voids the cognizance order entirely from inception, and the special court's cognizance order of July 2nd, 2024 was set aside. The court has been directed to begin afresh, this time with a hearing, within 8 weeks. And for our last story today, which is not even a story from today, it's from this week, but I thought it should be heard of more. A murder case from Tamil Nadu has produced a Supreme Court ruling that settles a question increasingly relevant in modern investigations. Can the police ask an arrested accused to reenact a crime scene, or does that violate the right against self-incrimination? The case is State of Tamil Nadu versus Ponusamy and others, where a woman was murdered and her body was found near a water body. The police had CCTV footage from near the crime scene, but it only captured the movement and gait of a person. So after the arrest, investigators asked the accused to walk and move in the same way as the figure on the CCTV, and then sent that footage for forensic gait analysis. The Madras High Court said this amounted to testimonial compulsion and was hit by Article 20, Clause 3, the fundamental right against self-incrimination. The Supreme Court, in a judgment authored by Justice Satish Chandra Sharma, sitting with Justice M.M. Sundaresh, disagreed and drew a clear line. If you're simply directing an accused to walk a certain way or imitate a movement for scientific comparison, that is not the accused disclosing personal knowledge of the crime. It's an analysis of physical attributes. But the moment you push the accused to demonstrate how they actually committed the offense from their own memory, that crosses into testimonial compulsion, and that is inadmissible. The court cautioned that a blanket rule against reenactment evidence would kill a legitimate scientific investigative tool. The appeal by the state of Tamil Nadu was allowed. That's all for today's edition of LiveLaw Daily. For full reports, detailed court updates, and breaking legal news from across the country, visit livelaw.in. And if you found this roundup helpful, don't forget to like, share, and subscribe to LiveLaw. Keep following us for everything that is law.